हेलो फ्रेंड्स, माय नेम इज़ श्रीनिवास। आज का विषय है ड्रंकन कंडीशन। इफ़ ए पर्सन इज़ इन्वॉल्व इन ए क्राइम and at the time of committing such a crime, if he was in a drunken condition under the influence of intoxication, whether his counsel can plead for intoxication condition as one of the ground for his trial. Under section 85 and 86, whether he can invoke to get redressal to that effect, like saying that he want to take a plea, saying the accused was under the influence of intoxication condition and he committed crime. If that plea want to be taken into trial, the main aspect which is very much important, that firstly a burden lies on the accused counsel to prove that the intention of committing such crime was not there with the accused, and he was not under the influence of any intoxication condition, that he intentionally did the crime or earlier motive was there with him. Under such motive he consumed liquor and committed the crime. That should not be the point. And the point for to be taken account is that when he was committing a crime, he shouldn't have knowledge of what he is doing under the consumption of intoxication. The main point for intoxication and his mind condition is very much important. He should not have knowledge about what he is doing. That is the main point in this plea. And the second thing is, the person who has consumed liquor, he should not have knowledge or earlier thought of doing such crime. The person who committed such crime in the condition of intoxication, if you want to take such plea, the main aspect in that trial should be that the person was not having any knowledge when you consumed liquor and suddenly the crime has taken place. That has to be proved by the accused counsel. The total burden lies on the counsel who is defending the accused. Section 85 and 86 will help him when he proves that he don't have knowledge of the crime or he don't have made out any mind to commit any crime. Section 85 or 86, then only he can invoke and he get protection under that particular section. So intoxication condition of a person, when he consumes any liquor or something, if he don't have any knowledge of what he is doing under that influence of that liquor, then only he can have the help of section 85 or 86. There are certain judgments to that effect, and one of the judgment is to invoke section 85 or 86 to safeguard the accused. Here is the judgment. It is AR 1957 Allahabad 667. It says the drunkenness of an accused at the time of committing an offence may be and must be taken into consideration to decide the question whether he did the act with the intention necessary to continue the offence charged with. There are degrees of intoxication, and that the drunken man may have the capacity for forming the intention necessary to constitute an act of offence. The question of intention must be determined in each individual case according to the facts proved and according to the accepted general principles. This is the judgment of Prabhu Nath versus State of UP, AR 1957, Allahabad 667. And another point is that when it is proved that the accused was dethroned and was incapable of forming any intention, he can press into service the defense of darkness or drunkenness. Suratannaya in REAR 1954, Madras 523. In 1954 Criminal Law Journal 672 page number. Here it is said, when it is proved that the accused was dethroned and was incapable of forming any opinion, he can press into service the defense of drunkenness. So these are the points. And another thing which is very much important is absence of any material to show that the accused was under influence of liquor at the time of offence being committed. Held the accused is not protected under section 85 or 86 of Indian Penal Code. These judgments are very much important. Another point is the burden of proving that under the influence intoxication condition or drunken condition, he was not in a situation that he can assess what he is doing, or the act which is done by him, he don't have knowledge about it. That is very much important. And the judgment to that effect is 1976 Criminal Law Journal 2010 page number. It says the onus to bring under the protection is squarely upon the accused, who is to prove that the intoxication envisaged was such as would render the accused incapable of forming the specific intent essence to constitute the crime. Dasa Kandha versus State of Orissa, 1976 Criminal Law Journal 2010. So the main point on which the whole section 85-86 rests is that one who committed a crime under the intoxication condition, he don't have prior intention of doing such crime. One thing. Second, the degree of taking intoxication should be such that he don't have knowledge about what he is doing or what activity is being done by him. That whole burden lies on the accused and his counsel only. And the third thing very much important is that intoxication under which the crime was committed, he don't have earlier mens rea or intention to do such crime. It was sudden act which was being done by him under the intoxication condition, or he don't have any knowledge about what he was done at the time of committing crime, or what is his mental condition, or what degree of intoxication was under his mind. That is very much important. So for the criminal trial, these things are very much important if you want to take plea under section 85 and 86 to protect your client. Thank you very much, friend. My name is Srinivas. Thank you very much for watching this video.